on to our second broker-only forum of 2021. I'm going to turn it over to our 2021 President, Doug Goss, and then we'll have Gov Hutchinson. If you have questions, which I'm sure you will, you can use the chat box to put them in. This is a meeting, so if you'd like to ask a question out loud, just go ahead and please raise your hand. To do that, at the bottom of your screen, you'll see something that says reactions. Ooh, mine's not there. But you can raise your hand if it's in reactions, or if you open up the chat, there's some buttons over there that you can also press to ask those questions, and we'll get that going. So welcome everyone again, and I'll turn it over to you, Doug. Thank you.
Thanks, Jody. Good morning, everyone. Thank you for being here today. One of my goals as president of SCORE for 2021 was to have more direct involvement between SCORE and the broker and manager members. So that's what brought about these meetings. This is our second broker meeting in our series. And today we're fortunate to have Assistant General Counsel of CAR, Gov Hutchinson, with us to give us updates on the reopening of our offices, updates on the COVID requirements that are no longer in place, eviction extension, and all the other great legal updates that Gov wants to share with us. As Jody mentioned, if you have any specific questions, you can go ahead and put those in the chat. Jody will be monitoring those, and then after Gov's presentation, we'll go ahead and we'll get answers to all those questions that we can. So thanks for being here, Gov. Appreciate it. And I'm going to turn it over to you to go ahead and share with us. Thank you.
All right, thanks. Good morning, everybody. And actually, I think it's a small enough group that you can, as you ask the questions, I'll just take them as they come. I don't know how many of you are actually going to show up at this meeting, but anyway, good to be here. Wish it were in person. To tell you the truth, it looks like I'm not going to be doing any in person till next year. So as you probably know, that your association is, you think I say this everywhere, but it's probably, it truly is one of my absolute favorites. I tend to come more often to your association than any other, but I won't be able to do that till next year. So even though most of the COVID stuff is over, as far as CAR people like me, I'm probably going to be pretty virtual for the rest of the year. As you probably know, the big thing I'm going to be doing the last few, September, October, November, December is talking about and teaching the RPA class. So hopefully you can all attend a session of that. That's going to be the big thing. It's just going to be a lot more convenient to do all those virtually. But anyway, let's talk about why we're here today. It's a nice time to be here in the sense that yes, I'll be coming one just for your association on August 26th. Not many of the associations actually got their own sort of private class, but you did. Thanks to Jody. Good job, Jody. Anyway, okay, COVID. Start with COVID. As you know, over a week ago, everything opened up. First of all, what does that mean for real estate? I think, as you know, it means basically when it comes to showings and open houses and door knocking and leaving the flyers, you are back to where you were pre-COVID, with one exception, which I'll get into in a second. In other words, no more PED forms, no more posted rules of entry, no more capacity limits, no restrictions on door knocking or dropping off flyers or marketing, no cleaning protocols, no nothing. The one thing we still are dealing with, of course, is mask wearing. And what is the basic rule? The basic rule is at a showing or an open house, if you're vaccinated, you don't have to wear a mask. And if you're unvaccinated, you should wear a mask, which then leads to the question of how exactly is that going to be handled? I think the best way is a listing agent and the seller have a conversation early in the relationship saying, how do you want to handle this? In other words, some sellers are going to still go to the extreme of, I'm just comfortable. I want everyone to wear a mask. And they have an absolute right to do that. It's their house. It's not considered illegal discrimination to force people to wear a mask. I mean, they could do that pre-COVID. They could do that after COVID. Some people are, really concerned about the regular flu. Anyway, the point is, just like a seller can say, you want to come into my house, you got to take off your shoes. A seller could say, you want to come in my house, you got to wear a mask. Some sellers might say, well, okay. The other extreme would probably be, you know what? It's the honor system. I'm not going to check anybody, but if you're maybe you put up a sign or something or whatever, basically saying, I'm assuming if you're not wearing a mask, you're vaccinated. And if you are wearing a mask, I want you to, if you're unvaccinated, I want you to wear a mask. Another possibility, of course, would be the seller who says, I want someone at the door actually asking people when they come in, are you vaccinated? Are you not vaccinated? And even a stronger possibility would be the seller saying, I want someone at the door not only asking people, but if they say, yes, I am vaccinated, show me some type of proof. So there are various possibilities how this can happen. I guess the other extreme would be a seller who says, I don't care about any of this. Nobody has to wear a mask, regardless of your vaccination status. I think the only risk of that be doing, if a seller had an open house like that, anyone who showed up and saw nobody wearing a mask would assume everyone's vaccinated, when that might not be true. So that might be a risk. Whereas I think the seller's protected if they at least put up a sign or make it known that I'm going to use the honor system here, but if you're if you're wearing a mask, I'm assuming that if you're vaccinated, if you're not wearing a mask, you're vaccinated, right? So there are various permutations how this can be handled, which, by the way, is also true for stores you go into. I don't know about you guys. In the last week, I've been going to a lot of grocery stores and car dealerships and all these places. I don't know about you guys. I have not encountered a single place where they had someone at the door asking me if I were vaccinated. Virtually every place I go, there's a sign. Please wear a mask if you're not vaccinated. That's pretty much the way I've noticed it. And it's the same rules for showing houses. It really is. Okay, so we got this mask issue, this vaccination issue that we still have to deal with. And this would apply to your broker opens, your broker tours. This would even apply to any other meetings you're going to have, marketing meetings or whatever. I mean, that's the fundamental rule. The fundamental rule now is if you're vaccinated. But I mean, like I said, companies, just like sellers and owners of houses, can be stricter. So let me transition to how this works from the perspective of, so now I've talked about your showings and your open houses. What about your offices? That slightly different rules. Cal OSHA came out with just a couple of days ago. First of all, when it comes to visitors to your office, not the people who work there, but clients, vendors, people, agents from other offices, visitors that come to your office, it's sort of the same rule that I just said for showings in stores. In other words, if they're unvaccinated, they should wear a mask. If they're vaccinated, they don't have to. But you, the broker of your office, can have whatever stronger policy you'd like. You could require all visitors to wear masks if you want. You could require them to prove their status. You could ask them their status. It's the same set of rules. What's slightly different, interestingly enough, and only a slight difference, is regarding the people that actually work for you. In other words, not the visitor, either the independent contractor realtor or the employee who works in your physical space. And you know what? For independent contractor realtors, once again, it's pretty much the same thing that I've been saying, in that if they're unvaccinated, they should wear a mask. If they're vaccinated, they don't have to, subject to your own rule. The only exceptions being if an unvaccinated person is alone in the office or alone in an interior office, they don't have to wear a mask. And yes, you can, just like a restaurant, you can open your kitchens and people can, just like in a restaurant, you can still go to a restaurant, be unvaccinated, and take off your mask while you're eating, right? So you could do that too. Now, the only thing that's really different is if you, for your employees, assuming you have W-2 employees who physically work in your office. Everything I just said is true, but there's a little more in that regarding the people that you allow, the people that work, employees in your office, you actually have to keep a written record of who's vaccinated and who isn't. For your independent contractor agents, you don't actually have, obviously you have to let them know that the rule is wear the mask if you're unvaccinated, unless you yourself want to have a stricter rule and just require everyone to wear a mask. But you don't really have to keep like a written record of it. But when it comes to employee W-2, maybe your office manager who is a realtor, but they get paid, they're treated as an employee, you do have to somehow keep a record of who's vaccinated and who's not vaccinated. Well, how about this? What if I say as a broker, you simply cannot come into work unless you are vaccinated? That is perfectly legal. I think that's where I work, CAR is going to do that. CAR is not, I am, share the personal information, I am vaccinated. And so I will be allowed to go back to work in the office. In other words, that's the decision my employer is making. And any employer can make that decision at this point. Basically, you want to come work in my office, you got to be vaccinated. That's a possibility you can do too. You can even do that with your independent contractor agents. In other words, they're not under the requirement that you have to keep a record of their status, but you could still have a rule. I don't want you coming in the office unless you're vaccinated. You could even say, I don't want you coming in my office unless you're vaccinated, even if you wear a mask. You could do that, which I think is what CAR is going to do. So the various permutations of how, and one more thing, you're going to love this one. If you are, and this applies, by the way, everything I'm saying applies to all offices, not just real estate offices. If you have a W-2 employee and you allow this person to come into work and they request to you, please give me an N95 mask, you have to provide one. Only if they're unvaccinated, only if they ask for it. But you actually have to pay for yourself an N95 mask to an unvaccinated employee who you allow to come into the office if they request it. So those are the sort of the two things for employees you got to worry about. Keeping a record of who is vaccinated and who isn't, and upon request, providing an unvaccinated employee with an N95 mask. Okay? Those are really the only two things that deal with how employees are treated differently. But another thing is, like all offices or businesses, if you have an outbreak in your office, defined as at least 3 people in your office test positive, 3 people who were working there, then you still have to notify the local health department about that, okay? And the other thing is, as an office owner, you still have to have an official COVID protection plan. Now, we make that very easy for you. CAR has one. You can go to the website, download it. Yep, we got a plan. And you also have to provide some type of training to your employees, about more or less what I've been saying. Once again, we have a template for you. we have a template for you that you can use for your training. It's pretty simple. Okay. Now, Doug asked a very good question, and that is, so I talked about the issue of you don't have to allow an unvaccinated employee into your workplace. Can you say to a unvaccinated employee, you know something, if you don't get vaccinated, you just can't work for me anywhere. You can't work for me remotely. I need you here and I need you vaccinated. Can you say that? Basically, you can, although you have to try to accommodate people in two situations. One, they have a disability that interferes with their ability, it's not safe for them or healthy for them to wear a face covering. And second is they have sincere religious beliefs regarding mask wearing. I don't know how the heck you determine what's sincere and what isn't. But people who have fall into either of those two categories, you try to accommodate them. I can't figure out how you'd accommodate them other than allowing them to work remotely. Because just because you have to accommodate them doesn't mean you have to let them come in and work amongst your other employees, even though they're unvaccinated, without a mask. But you probably can't fire that person for refusing to wear a mask. You probably have to accommodate them. And accommodate them, the only thing I can think of how you're going to accommodate them is allow them to work remotely, right? Joseph, ask me your question, please.
Yeah, so in regard to showing of property, so we've got an apartment that we're showing, hired an agent to show. Obviously, we own the property, so we said we don't care about masks. But the agent asked me a really interesting question. Can I enforce the rule that if you're not vaccinated, you can't come in unless you wear a mask? And does an agent have that authority?
So in other words, who owns this property?
Pardon?
Who owns the property?
Our family does.
Yeah. So in other words, the owner of the property is saying, I don't care about masks.
That's what we have said.
Right. Well, maybe the agent is uncomfortable working in that environment. So the agent, you get a different agent. You know what I'm saying? I mean, the agent obviously can say, well, that's your decision, but I don't want to work in that situation. So then you're going to have a discussion. Do you want this agent bad enough to allow them to have that rule? Or do you say, well, that's my rule, so you don't like it, maybe I'll get another agent who's okay with that. You see what I'm saying?
Got it. Just wanted to make sure that I was on good solid grounds.
Yeah. The only thing I'm saying is sort of what I said before. I was sort of talking about open houses. I'm just concerned that if the property owner says, I don't care about masks, I don't care about, you just don't have to wear a mask, are other people who come in, I don't know, maybe a showing is probably just one group at a time, but you just make sure that the people who come in understand that there could be people in there who are unvaccinated who aren't wearing masks because the seller, the owner of the property, isn't requiring it. So I mean, if I just came to that property, I might assume unless you told me that I don't require anyone to wear a mask. So I need to sort of know myself, if I come in and there are other people there, that the other people there might be unvaccinated, even though they're not wearing a mask. So that's the concern
James,
I would have.
at my meeting.
I'm sorry, someone talking to me. Anyway,
We're good.
so that's a good question. Getting back to Doug, yeah. So what if the employee asks for a mask? Do you have to provide an N95? That's a good question. We're talking about the unvaccinated W-2 employee who you are allowing to work physically at your location, and they ask you for a mask. If they don't specify an N95 mask, can you just give them any old mask? Great question. What do I do when it's gray like that? I'm conservative. I'd say, yeah, give them an N95. That's the safe thing to do. Victor, very good question. What if it's not the question of the property owner is asking for, oh no, it's actually the same question, I guess. The property owner wants to see, you say proof of negative COVID vaccine. Maybe you're saying proof of a negative test. I think a property owner could say, well, I'm not going to ask you to prove that you're vaccinated. I want proof that you recently took a COVID test. And we're not, in other words, yes, I think a property owner could do that too, as could an office owner. I think a key thing to remember here, of course, is you got to treat everyone the same. You can't, if you're going to ask one person for that type of proof, you'd have to ask everybody for that type of proof. You couldn't make distinctions. But as I said before, it's their house. They can have whatever rules they want. And it's your business. And you can have whatever rules you want. I know what you're thinking. Well, that's not really true. I can't say only white people can come into my office. I can't do whatever I want. True, you can't do whatever you want. But when it comes to this whole issue of COVID and mask wearing and requiring proof of vaccination or requiring a negative test, yes, you can do what you want. It's not discrimination, it's legal discrimination, if you want to look at it that way. And maybe this will change. Maybe there'll be a court case saying something else, but that's the way it is right now. Okay. So Joseph, again, should brokers provide their agents with signs? I mean, I just think from what I've been saying, it's probably a good practice for the seller and the listing agent, obviously, to agree together on how we're going to handle these things. And maybe it's a good practice then to put up some type of sign saying what the rule is at this house. In other words, please wear a mask if you're not vaccinated, or please provide proof, or whatever it is, whatever what the various options I gave you. I don't think it's a bad idea to put up a sign. Stephen, I'm not sure what you mean by, is there pushback? Pushback from whom? If you want to unmute yourself and let me know.
The question is there any pushback from any of our trade groups to mitigate this, what you just said, legal discrimination?
Like which trade groups are you talking about? Like CAR?
Well, our trade groups. That's the only trade groups that I would be mentioning in this environment.
You mean your local associations, in other words?
Just associations, NAR, CAR.
I don't think anyone's, no, on the official association level, I don't think anybody is pushing back on, in other words, to say that these rules are too strict or something like that.
Well, like you said, you know, if you're black, right, they
Right.
can't say you can't come in and out, but then
Right.
you can legally say if a person chooses not to get vaccinated
Right.
because they're concerned or they're not.
Right. No, I understand.
Right?
Now I understand.
And then there's different treatment. So it reminds me of the
Right.
South in Jim Crow land when there was a white drinking fountain and a black drinking
Right.
fountain. Now
Right.
they're vaccinated and non-vaccinated, and we're heading down the same path.
Yeah.
And so it's concerning for a lot of people out here. So we're wondering
Yeah.
if we're just following all this or if there's any discussion.
Yeah. Now I understand what you're saying. Yeah. As far as I know, CAR, NAR, local associations, as an association, no one's like challenging this. I do know that individual people are filing lawsuits to try to get a court to say this type of discrimination against unvaccinated people is a problem. But no, on the association level, I think the position is, yes, this is okay. You might have heard, you read in the paper what I read in the paper yesterday, I think it was, or the day before, that hospital in Houston where they terminated 153 doctors, nurses, employees of the hospital because they were unvaccinated. They just said, you can't, if you don't get vaccinated, you can't work here. And they immediately filed an action, and a federal judge said, nope, the hospital was okay. They had the right to do that. So that was just in Texas. I suspect the court would say the same thing in California if that happened. Maybe this is going to change. Maybe there's going to be a big lawsuit about this. But for now, number one, what I'm saying is sort of the law. Number two, yeah, on the real estate trade association level, there isn't any, there's support of this. There's no official challenge to this on that level, on our level. You know, I work for CAR. You guys are members of CAR. So on that level, yes, no one's pushing back at that. Victor, you're right. It's so complicated. Yes, I know about Chris Paul, who's got COVID even though he's vaccinated. Yes, and it's incredibly complicated if you're trying to think about traveling. I've given up on traveling until they figure it all out. But anyway, yeah, sometimes maybe the COVID test, the negative COVID test is actually better than proof of vaccination. Who knows? But I'm just telling you the way it is right now. So that's sort of where we're at right now. Okay, very good questions, obviously. Let me keep going. We got plenty of time today, so we can come back to this. But that's my sort of stuff on COVID rules, and Neil, you're exactly right. You got it. Whatever rule you have, just treat everyone the same. Next thing, that big news just happened this morning. To no one's surprise, the federal government extended the federal eviction moratorium for a month. They extended the foreclosure moratorium for a month. And as you probably have heard, if you read the paper, on the state level, there's a lot of negotiation going on. I'm 99% sure there's going to be a state extension to the state eviction moratorium. Where I live, LA County has already extended for 3 months. San Diego County has extended for 3 months. The federal extension was only 1 month, and they said this is the last time there's going to be an extension. California, I don't know any more than you do, other than what I just said, but they have like 6 days to make up their mind. I'm thinking we're going to hear in the next couple of days of some type of extension to the California moratorium. So for sure, the foreclosure moratorium is another month, for sure. That applies to every lender in California. Because there's a California law that says California lenders, even if it's not a federal loan, California lenders have to comply with the criteria that are used by Fannie and Freddie, which basically means you can't foreclose on someone if they have a COVID reason for not paying. So there's another month of that. What about the rental situation? Remember the key things about the eviction moratorium. Number one is you can't evict someone for not paying rent if they have a COVID reason. But more importantly for you guys as a realtor, I mean, that's important for you if you have a rental property, obviously. But more importantly for you guys is the fact that you need just cause to evict a tenant, even though if they haven't, for no fault evictions. I mean, normally, without this eviction moratorium, if you own a single family home or a duplex or any rental property newer than 15 years, and you want to evict a tenant, you do not need a reason. You just don't need a reason. For now, and it's been extended for another month, and maybe it'll be extended more than a month. Even if California doesn't extend it, the feds extended it for a month. You do need a reason to evict someone. And the 3 reasons that typically you can use are, number one, I want to move in myself or a family member. Number 2, I want to take the property off the rental market. completely, or number three, really important for you, if I have a home for sale and I get a buyer who signs an offer and the seller accepts it, and the buyer's offer says the buyer will occupy, you can evict the tenant. By the way, in LA County and San Diego County, you can't, that's not a legitimate reason. And I don't know, I don't keep up anymore whether, you know, Santa Clara County, Alameda County, if any of your counties are restricting no-fault evictions more strictly than the state is. But the state, remember, says you can evict someone from a single-family home once you get a buyer in contract. You can, or the seller could say, you know what, tenant, you got to leave because I'm taking the house off the rental market. By the way, I'm assuming that the lease is over, right? If they're on a lease, you can't evict them to the end of the lease. But so can a seller say, tell you what, can I evict the tenant because I'm taking it off the market and then sell it? In other words, is that a way so I don't have to wait till I actually get a buyer in contract? And the answer is yes, as long as you understand that if a property owner takes the house off, is evicting the tenant on the basis that they're taking the house off the rental market, the house has to stay off the rental market for at least 2 years. Meaning you take it off the rental market, then a month later you sell it. That buyer can't rent it out either for a year, for 2 years. Of course, maybe they don't care. Or you just wait until you get a buyer in contract. Then you give the notice, and then that buyer, even though they wrote an offer saying, I am buying this with the intention of living in it, maybe a few months later they decide to rent it out, they could rent it out. They wouldn't be under this 2-year restriction. Thank you, Diane. You're just telling me something. San Jose is extended. So if you're in San Jose, do what San Jose says. I mean, cities are stricter. LA is very strict. LA City is much stricter than LA County. And interesting news for you guys that there's no more a restriction on rent increases. By the way, under state law, you can increase someone's rent now, unless the city you're in, like San Jose, which apparently is ending their moratorium. Unless you're in a city like LA or something, that Berkeley, whatever, has a city stop on rent increases, everyone can increase their rent now. With but there are also restrictions on that, right? Because if you're under California rent control, meaning you have a rental property that's older than 15 years, you can only increase it by 5% plus the inflation rate for your area, which you can just Google or call CAR, will give you that number. And guess what? Even if you're not covered by California rent control, you're not covered by San Jose rent control because you're renting out a single family house, there is currently a statewide 10% limit on rent increases on residential, okay? So no landlord right now can increase someone's rent by more than 10%. Some places it's going to be 5 plus inflation, or if you're in like LA City, which has a strict local rent control, that's going to be a restriction too. By the way, general comment. Those of you that have clients with tenants, don't send the notice, the 60-day notice to evict them. Make the client send it. Because the only reason I say that is, unless you're 100% sure that there's no local ordinance in your area that has any specific tweak on that. Because the city of LA, and I'm not sure if any cities in your area, have recently passed laws that say, if you send a tenant an improper eviction notice, not only will it not be effective, but the person who sent it can be personally fined. So I'm going to say it's a real lot safer to, when your client says, hey, can you send the 60-day notice for me? You say no. get an attorney to do it for you. It's too complicated now. And there, I don't know about, like I said, in your area, maybe the only negative of doing that would be the eviction notice wouldn't be effective. But if you were in LA or San Diego, the person who sent the notice could be subject to a penalty for sending an improper notice. It's that complicated. Carl, unmute yourself, please.
Okay, so yes, you didn't mention the cause for eviction substantial repair, the exemption. Is that still in play?
You know why I didn't mention that, Carl? Carl is exactly right. Carl actually reads the stuff we put out. Thank you, Carl. There is a fourth legitimate reason to evict someone, but it's because you need to do substantial repairs to the property. But hold on, that sounds good, but it only works if it's for health and safety reasons that you need to do these repairs. In other words, because the property is not habitable. In other words, the landlord is admitting this property that you're living in, tenant, is currently not habitable. I don't know if you want to tell a tenant that, because then that opens up another option that they have to come after you. Now, I guess this could be more legitimate. Let's say you had a fire or a flood or something, and the house was damaged. So in that case, clearly, yeah, you could evict the tenant and say, listen, I'm evicting you because it's necessary to make these repairs because based on what just happened, it's not currently habitable. And you know what? You wouldn't have to rent back to that same tenant once it is habitable. You can just evict that tenant. Like I said, but the reason I didn't bring that up initially is because some people hear that and they say, great, I got a listing. I need to rehab the property. I'm evicting the tenant. But no, that's only if it's for health and safety reasons, which means you're admitting to the tenant you're already violating the law by having them in an uninhabitable property. That's my concern with that. But you're right, Carl. Yeah. Yes, Doug.
So going back to the maximum 10% rental increase, is that for existing tenants, or if you have a tenant, a long-term tenant who has been there at below market rates and they vacate, and you bring a new tenant in, you put it back on the rental market, are you restricted to that 10%, or you can go market value?
Market value. Yeah, I was just saying for current tenants, and that's probably going to go away soon. That's we're trying to get that removed. That's saying that 10% says based on we're in a state of emergency in California based on COVID. Well, we're really not anymore in a state of emergency. So we're trying to get that rescinded so that even with existing tenants, you could increase by more than 10%, unless you come under California rent control or local rent control. Greg Haas, you're exactly right. Use an eviction company or a lawyer. James Dill, did you have your hand up? Or
yeah, I sure did. Thanks, Gov. The question I just had, going back to your necessary repairs, when you tell them to move, do you pay their next apartment? Do you have to pay all the things for them to move, and perhaps maybe the first rent?
Very good question. If you're evicting someone because you're taken off the rental market because owner move in or because of substantial necessary repairs, yes, you have to give them a month's worth of relocation. If you're evicting them because you have a buyer in contract, you don't even have to pay them a month. That's another reason why that's sort of the best way, I think, to evict someone in the context of because you want to sell the house. I know sellers, you want to fix up the property before you put it on the market. I understand. But I'm just saying, can't really do that very easily right now. Now, if this doesn't get extended in 6 days, you will be able to start doing that. But if the CDC extended for a month, there's no way California is not going to extend this for at least a month. And your county or whatever can do whatever they want too. LA County and San Diego County have extended for 3 months. And in LA and San Diego County, you can't even evict with a buyer in contract. You simply cannot evict for no fault. period. And LA and San Diego just passed these onerous penalties on landlords who send the improper notice. So it depends on where you are. And like I said, unfortunately, I don't keep up with local rules you have in your area about this. Okay. All right. Let us move on to other things. We got time. That's the big stuff on COVID showing, COVID offices, COVID evictions, and COVID foreclosure. Everything is changing constantly, as you know. So you just stay tuned. Okay, Diane, this all applies only to tenants who are not paying. Well, remember, there are two things we're talking about here. Tenants who are doing bad things or tenants who are not doing bad things. Tenants who are doing bad things like damaging the property, criminal activity, creating a nuisance, not allowing you to show, subtenants without permission, pets without permission, you can evict them right now. What if the bad thing the tenant is doing is not paying rent? Well, if they don't have a COVID reason, you can evict them right now. But if they have a COVID reason, you cannot evict them right now. So that's one part of this. But the other part of this is what I was talking about just now, which is the tenants who aren't doing anything wrong. That's where you have limited reasons to evict. Yes, tenants who are doing something wrong, you can evict them right now, unless the thing that they're doing wrong is not paying you because of COVID. The other thing to remember is if I'm a landlord and I got this tenant who's not paying me because of COVID, there is rental assistance money there now. You go to the website housingiskey.com. You look up the city of San Jose, county of Santa Clara, wherever it is. And that website, once you locate the jurisdiction where the property is, that will tell you how to apply for rental assistance. There is billions of federal dollars has come to California for the precise purpose of compensating landlords. Thanks, Jody, that is the website, for tenants who owe them back COVID rent. The problem is there's a couple of strings attached. On the federal level, the problem is you're only eligible to get this assistance if the income of the tenant household that owes you the back rent is less than 80% of the Santa Clara County median income for a tenant household of that size. Greg, you're exactly right. The way it works is you go to the website, you look up your jurisdiction, you say, send me an application. They will tell you, please send us your tenant's email address. They will then send an application to the tenant, and the tenant has to fill it out also. You would think the tenant would want to do this, because if the landlord gets rental assistance, the tenant no longer owes the landlord this back rent. Because, by the way, the tenant does owe this money. There's no forgiveness under the law. It's just that you can't evict them right now for not paying that money. By the way, what about when the eviction moratorium is finally over? A month from now, 3 months from now? Well, then the tenant immediately has to start paying the full 100% of the rent, or you can evict them. And if they haven't been paying 25%, even if they're a non-paying COVID tenant, they should have been paying 25% since last October. And if they haven't, you can evict them immediately. What about the COVID tenant who has been paying the 25%? This eviction moratorium ends. Can I immediately demand that they pay me the 75% they haven't been paying me? You can demand it, yes. But you're demanding it because it's a personal debt. You cannot evict them for not paying you back the back rent. You can evict them for not paying the entire rent once the moratorium's over. You can evict them if they haven't been paying the 25%. But if they have been paying the 25%, And as soon as the moratorium ends, they immediately start paying 100%. How do I get that 75% they haven't been paying me? You can sue them, or you can go through this process I just talked about, where you and the tenant apply for this federal money that is being administered on the local level. Now, I said the first thing they're going to determine is, do you have an eligible tenant, which is defined as the income of the tenant household. It's a household of 4 tenants. Is their income now with COVID less than 80% of the median income of a tenant household of 4 in Santa Clara County? And you can Google that number very easily. You can call CAR on the hotline. We have that number at our fingertips. We can look up for you, or you can we have our Q&A on tenant eviction moratorium and rental assistance also has a link where you can easily figure out what that number is in your county. If the income of your tenants right now is less than that, you're eligible for the money. If not, you're not. Then the next string that's attached is, even if you have an eligible tenant, under the state law, let's say that you have a tenant owes you $30,000 of back rent, but you're eligible because they're an eligible tenant. At this point, the county or the city is going to say, okay, they owe you how much? 30,000. Okay, we're going to give you $24,000. You're going to say, but I really want 30 because they owe me 30. It says, well, if you want the money, you got to forgive 20%. But if you're reading the paper, the governor is saying, since California has this budget surplus, I want to get rid of that requirement. I want to get rid of that limitation. So in other words, I think it's quite likely, maybe even this week, where the rules are going to change and a California landlord who has an eligible tenant who owes them back rent is going to be able to get 100% of the back rent, not just 80%. Nick, getting back to the fundamental question, though, I keep saying, what does it mean that tenant has a COVID reason for not paying rent? Well, here's how. The only way you know if your tenant has a COVID reason for not paying rent is you send them an eviction notice, a pay rent or quit. And from now until the end of the month and maybe beyond, you don't send them the normal 3-day pay rent or quit. You got to send them the COVID 15-day pay rent or quit, which on zip form is called the PRQTP for transition period. You send them this 15-day notice. Attached to this notice is this declaration of COVID financial distress. If the tenant signs that under penalty of perjury and returns it and says, yes, I have a loss of income based on COVID, either loss of job or medical expense, whatever, you have to take their word for it. So you can't require any proof. If they're willing to perjure themselves, then that's the way it goes. Okay, maybe this is going to go away in a week, unlikely, maybe in a month, maybe 3 months. Greg, does that mean that there's not effect to the tenant? I mean, if the tenant never, if you sent a tenant a pay rent or quit and they didn't respond within 15 days with the declaration of COVID financial distress, they can be evicted.
No, Gov, I'm referring to the paperwork. We had to notice them last year of a lot of their rights. They had to notice us that they were affected by COVID. Some tenants didn't send that back. They're not sending that back. There's no real effect to that.
Right. The problem would be if the landlord didn't send the tenant that form you're referring to, just the notice form, then you'd have a problem getting this money, even if you were eligible to get this money. So remember what Greg is referring to. Remember, there was another thing. There's another separate form that was required to be sent to all tenants behind in their rent, telling them about their rights. And that's like a precursor needed to be able to assert these rights to even get to evict them in the future. But yeah, the fact that the tenant didn't,
It sounds like that was a one-way street.
exactly, yeah. The tenant didn't have to like, I mean, obviously, anything you send to a tenant, you want them to acknowledge that they got it. But I mean, you don't want the tenant to come back and say, I never got that one. What are you talking about? So, I mean, but that's true for all notices.
Thanks, Gov.
You're welcome. Okay. So getting back to, so anyway, so enough of COVID for now. We can come back. Since we're all here, let's talk about the June forms release. As you know, every June and December, CAR makes changes to or eliminates, rarely, or adds new forms. There's not much this time around, which is probably good. There is one I'm going to spend a few minutes on. There's one significant new form, which actually came out more like a couple of weeks ago. And then there's one coming out this week, if it didn't come out already. But let me talk about the one that came out a couple of weeks ago. And that is the incredibly complicated, that I will try to simplify, fire hardening and defensible space form, the FHDS. Let me put this in context. Some of you have been around as long as me, 35 years. You remember when there were no disclosure laws in California. Let the buyer beware. That changed in '86 with the TDS. And over the years, periodically there'd be new disclosure forms added. The agency form, the NHD, the lead paint, the environmental hazard booklet, the earthquake booklet, the lead paint booklet, the water conserving plumbing fixtures and carbon monoxide detector. But we haven't had a new one for over 10 years. Well, now we have a doozy of a new one. First of all the forms I just mentioned, remember, they're not, all disclosure forms are not required by law. So people always ask me, what is actually required by law when I sell a house? What are the disclosure forms I'm actually required to do? And up until this new law, I said there are 5 of them. The TDS, the SPQ, because it's required by the purchase contract, the lead paint, the NHD, and those 4 booklets. NHD, TDS, lead, SPQ, 4 booklets. I grouped them together. Thank you, Jody. She's so on top of this stuff. So now, though, I changed my tune. I now answered that question by saying there's actually 6 mandatory disclosure forms. What's the 6th one, people ask? It's the FHDS. Now, since January 1st, there was a form called the HHDA, the Home Fire Hardening Disclosure and Advisory. That has been replaced by the FHDS, because everything on that form is on the FHDS plus more. Okay. By the way, unlike the other 5 forms mentioned, this new form is only required if your listing is in a high or very high fire hazard severity zone. All of us that live in California, there are 4 possibilities. You're not in a fire zone, you're in a moderate fire zone, you're in a high fire zone, or you're in a very high. I was talking to Lake County about a week ago. Their entire county is high or very high. I suspect that's not the case in Santa Clara County, but I don't know. So the point is, every time you have a listing now, you have to determine right up front, is my listing in a high or very high? How do I do that? Through your NHD company. The NHD report, as you know, has 2 fire zones. One says very high fire zone, one says wildland fire area. If neither box is checked, you're not in a fire zone, you don't need this form. If the very high is checked, obviously you're in a very high, you need the form. If very high is not checked, but wildland fire box is checked, that means you're in a moderate or a high. But Gov, you just got through telling me I only need this form if I'm in a high. How do I know if I need the form? You just dig deeper. You go to your NHD company will easily be able to tell you whether you're in a moderate or a high, and they'll tell you. Some of them I've noticed have even modified their report to put it in the report itself. In other words, they're not required by law in the NHD report to distinguish between a moderate or a high, but they will do it for you. Okay, so now I've figured out that I'm in a high or very high. Then this form is required. And I'm assuming that this is in a TDS transaction. So if a TDS is required, this form is required if you're in a high or very high. In other words, if you're a probate sale, REO sale, bankruptcy sale, sale by a trust where the trustees were never on title, TDS isn't required, this isn't required. So the same exemptions apply. But let's say it's a TDS transaction, property built before the property is in a high or very high. So I pull out this form, listing agent. The first 3 paragraphs is the same as what used to be the HHDA. It deals with fire hardening. It's purely a disclosure. You have your seller answer the 6 questions in paragraph 3 to the best of their ability. Actually, to tell you the truth, if the house was built before 2010, the seller doesn't have to even answer those questions. I'm sorry, if that property was built after 2010, the seller doesn't have to answer those questions. But the form itself is required because the defensible space part of the form is required on all sales of high or very high, regardless of when it was built. This is the first complicated thing about this. Anyway, you've determined you're in a high or very high. You pull out the form. Next, figure out if the house was built before or after 2010. If it was built after 2010, the seller doesn't have to answer the 6 questions in paragraph 3. If the house was built before 2010, the seller does have to answer those 6 questions. But that's just a disclosure. The seller doesn't have to do anything. They disclose they have a wood roof. Buyer says, oh, I don't like the fact you have a wood roof in a fire zone. I want you to put on a new roof. The seller can say, you do it. You buy it, you put on the roof. I don't have to do anything. I just have to disclose. But then we come to paragraph 4 of this FHDS form. Okay. This is the defensible space part. And this part is relevant regardless of when the house was built. And this is going to require you and your seller to determine which of the 4 options in paragraph 4B are relevant to this transaction. Let me put this in perspective. If you live right now in California in a high or very high fire zone, you are required to be in compliance with the defensible space law. You are required to have 100 foot of defensible space. And you're susceptible today to CAL FIRE or the local fire company coming out to your property on a random basis, checking out to see if you have it. And if you don't have it, they can fine you. The only thing new about this law is not only do you have to be in compliance, you have to be you have to go out and get someone to inspect you to see if you're in compliance. You have to go get documentation. You got to be proactive. Okay. So I say, to me, the more important thing is you should be in compliance anyway. It shouldn't be a big deal for you to have to go out and get an inspection. You should be in compliance. Okay, put that aside. But there are 4 possible situations here. So once you've determined that you're in the high or very high, in order to properly complete paragraph 4B of this mandatory form, by the way, Jody, is that the Q&A we have there? We're updating that Q&A.
This is the defensible space quick guide.
Okay, don't put up the Q&A because we're modifying it today.
Okay, I won't find that.
Yeah, by the end of today, we're going to have a updated, modified Q&A on what I'm just talking about right now. But it's not, don't use the old version is not inaccurate, but it's going to be a better version later on today. Okay, the quick guide is fine though. Okay, but anyway, so once again, I'm talking to you as a listing agent. You've determined you're in a very high or high, so you know you got to do this form. You've had your seller answer the 6 questions or not, depending on how old the house is, and you come to paragraph 4. There are 4 choices in paragraph 4B. You need to figure out which one is relevant to this transaction. 2 of these paragraphs, 4B1 and 2, say there's no local ordinance. Paragraph 4B3 and 4 say there's a local ordinance. In other words, some counties don't just have the California 100-foot defensible space, but they have a local rule. I've seen some counties say you got to have 200 foot of defensible space. Some counties say the grass has to be not 4 inches, got to be 3 inches, whatever. Counties can be stricter. That's fine. But some counties, not only are they stricter, some counties actually say, you know what, seller, if you're selling your house, you have to bring it up to, I mean, you should be in compliance anyway, but when you sell it, you actually have to make sure you bring it into compliance and get an inspection, get someone to come out and inspect it to get that verification. Some counties, like I've already checked Napa, Sonoma, and Mendocino, have not checked Santa Clara. They have a local ordinance, but the local ordinance doesn't require the seller or the buyer to do anything regarding inspections. So for Napa, Sonoma, and Mendocino, and probably Santa Clara, even if you have a local ordinance, since the local ordinance doesn't have any specific point of sale mandate or specific local inspection, you don't care. I'll tell you, if you're in the Lake Tahoe area, they have a local rule, you have to do something special. If you're in Big Bear down here, you got to do something special. So in other words, the next step on your, so the first point on your checklist is right, is to determine if you're in a high or very high. The second point on your checklist is figure out if my county or city has a local ordinance that either requires the seller to do something at point of sale or requires the buyer to do something special after close. Since I don't know, how would you know in Santa Clara County? If you just pick up the phone and call either CAL FIRE local office or your local San Jose or Santa Clara Fire Company, they will know if there is a local law that you need to worry about. Chances are they're going to say, I mean, maybe there's a local law, but the local law doesn't require you to do anything special. Once you find that out, and probably only have to do this once, right? Once you find out going forward, you remember, yep, there's nothing special in Santa Clara County that requires us to do anything. If that's the case, you would, by the way, if that's not the case, then you're going to fill out, check the box on either 4B3, which says seller must get an inspection by close of escrow, or alternatively 4B4, buyer must do something special within a month after close. I think in 99% of your transactions, if not all of them, you're never going to deal with paragraph 4B3 or 4, because I suspect, unless Santa Clara County is different than Sonoma, Napa, Mendocino, you probably, I could be wrong, but you probably don't have a local ordinance requiring a special local inspection or point of sale. I'm just assuming, I could be wrong. So let's assume that my assumption is right. Well, then you're either going to deal with paragraph 4B1 or 2. And this is going to be relevant every transaction you do. 4B2 says, if the seller of your listing has, for some reason, within the last 6 months, had CAL FIRE or a local fire company out to the property to determine if you're in compliance with the California 100-foot rule, then the seller is going to give that documentation to the buyer. You know something? I think you would have done that anyway, right? Aren't you trained as a listing agent that if your seller has in their possession any government inspection regarding the property, you're probably going to give it to the buyer. So you were probably going to do that anyway. So, but this now is very specific. Once again, assuming no special local ordinance with different inspection rules, if your seller happens to be in possession of some certificate from not a private inspector, from a CAL FIRE or local fire company, a government fire company, saying you're in compliance, just simply give it to the buyer. You would have done that anyway. I think most of the time when you ask the seller this question, they're going to say, no, I didn't get any inspection or anything. I think most of your deals are going to default to paragraph 4B1, which says the buyer has to agree that within a year after close, they are going to go to reach out and get an inspection of their property to get documentation that they're in compliance. That's the big news. The big news is buyers now are going to have an obligation to do something after close. Laura, very good question. You were reading my mind, and Gene, I'm going to get to your question in a second about whether this is a disclosure versus an addendum. Okay, so follow along with me. The paragraph 3 about the fire hardening, that's pure disclosure. Paragraph 4, the one I'm just talking about, defensible space, if it's the seller has the documentation for some reason and they're providing to the buyer, it's pure disclosure. But let's say we're in the situation, which I think is going to be more common, where there's no local ordinance requiring any special local compliance, and the seller doesn't have any within the last 6 months evidence, documentation that they're in compliance. So we're defaulting to 4B1. Now, if you think about it, this is an addendum because you're giving this form to the buyer, asking them to sign it. By signing it, they're agreeing to do something. So it really is an addendum. The seller is giving this form to the buyer, say, buyer, you need to sign this because you need to agree to do something within the next year. So in that sense, it's an addendum. So you could give this form, assuming that's the case, assuming, once again, if the seller has documentation, just give it to him. Give him the form and give him the documentation, you're good. Assuming the seller doesn't have the documentation, which I think will be more common, you're going to be not checking any of the boxes 4B2, 3, or 4. You're just going to be defaulting to 4B1. You're going to be giving the form to the buyer, perhaps in the form of attaching it to a counteroffer. And you're saying to the buyer, you need to sign this form. Or alternatively, you don't have to attach it to a counteroffer. You can just provide it as a disclosure because under the purchase contract, the buyer is required to sign any disclosure that they give to you. And if they don't sign it and return it, you can cancel them. So either way, from the seller's side, you want the buyer to sign this form agreeing to do what they're supposed to do within a year. What if the buyer says, I refuse to sign? I am not taking responsibility to go call CAL FIRE to get an inspection done in the next 12 months. Well, you could say to the buyer, you're required to do this by law, whether you sign the form or not. The buyer says, I don't care, I refuse to sign. So I asked CAL FIRE, I said, who enforces this, by the way, and I said, buyer refuses to sign. Escrow closes. Is there any negative consequence to the seller allowing it to close without a buyer's signature? You know what CAL FIRE said to us? They said, we'll get back to you on that one. Since they have not committed that there is no negative consequence to the seller, if I were a conservative seller, I would say to the buyer, sign this or I'm not selling you the property. I'm assuming in the seller's market we have right now, buyers aren't going to refuse to sign it. It's hard enough to get a house now. If you're going to make that your obstacle, I'm assuming a buyer is going to sign it. It's the law anyway. But anyway, if I were a seller and the buyer wouldn't sign, I probably wouldn't sell the house until I got clarification from CAL FIRE. Can I be punished as a seller for allowing it to sell without the buyer agreeing to do this? Okay. So, but anyway, so now the listing agent has done their job. But let's say you're the buyer's agent. What's your job? Not really clear yet, but generally the standard of care in California is when you're giving a form, when you're a buyer's agent and your buyer receives a disclosure form from the seller, you're supposed to be able to explain it to them. So I think, hopefully I'd be proven wrong one day, but until I'm proven wrong, I'm going to say your standard of care as a buyer's agent is to simply explain this form that the buyer just got. And chances are 4B1 is going to say buyer is agreeing to do this within a year, to reach out and get documentation of compliance. So the buyer might look at you and say, how do I do that? Once this escrow closes, I have a year to do it. What do I do? And the answer is simply tell your buyer. Of course, they'll probably ask you to do it for them. And it's up to you. You don't have to do anything. Once escrow closes, your responsibility is over. But before escrow closes, I would say to the buyer, here's what you do. Call CAL FIRE. Call the local CAL FIRE office. CAL FIRE is aware of this law. CAL FIRE is in the process of hiring many, many, many new inspectors because they are completely expecting the phone calls from buyers saying, I just bought a house. Could you come out and inspect it so I can comply with my agreement to obtain documentation of compliance within a year? CAL FIRE is ready for this. But what if you call CAL FIRE and they say, I'm sorry, your property is not within our jurisdiction because it's not a state responsibility area, it's a local responsibility area. And in some local responsibility areas, CAL FIRE has contracted with the locals. But let's say this is in San Jose or something. I don't even know how many high or very high fire districts you have, if any, in San Jose. But let's say for some reason you have a San Jose or Santa Clara very high or high fire zone. The form is required. The buyer buys the house. The buyer calls CAL FIRE and they say, we don't do it. We don't have jurisdiction. Now what do? Well, now you call the San Jose or Santa Clara Fire Company and say, I just bought a house. I'm supposed to arrange to get an inspection within a year so I can have documentation of compliance. Since it's not CAL FIRE's area, will you come out and do it? This is what we've learned. Some of these local fire companies will say, sure, we'll be right out. Let's make an appointment. But some of these local fire companies are saying, maybe most of them are saying, we don't do that. We don't just come out upon request. Maybe we do random audits, maybe if we get a complaint, but we are just not going to just do this. So see what happened? The buyer has bought a house in a high or very high. CAL FIRE won't do it and the local company won't do it. You are done, buyer. You don't have to do anything. Document you spoke to Joe Smith at San Jose Fire Company. They told you they don't do it. I'm done. If there's no one to do it, I don't have to do anything. End of story. Okay? All of this is going to be explained in the Q&A that I just wrote. It's going to be released today. Let me go back to questions first. Gene, defensible space. On the form that we're talking about here, the FHDS, it references the Public Resources Code that defines California defensible space rules. So you just point that to your seller and say, this is what you do. There's certain things you got to do within 30 foot. There's certain things you got to do within 100 feet. That's the answer. The answer is, what does the Public Resource Code say you have to do? Laura, yes, it would be correct to say if a TDS required, this form is required if it's in a high or very high. So just because a TDS is required, if it's in a moderate or no fire zone, it's not required. Doug, here's a very important point. The effective date of this law is July 1st. Here we are. Why am I worrying about this on June 24th? Because it's effective to all transactions that close after July 1st. So if you're in escrow right now, I'm suspecting you're not going to close in the next week. Hopefully you are, which means you got to do it. I just heard about this. That's terrible. I never did it before. You mean I got to give it to my buyer right now? Yes. Does my buyer have the right to rescind the deal? Yes. It's like the TDS and the NHD. It delivers a 5-day right of rescission. So that's an unfortunate situation. I mean, we did put something out about a month ago that not everyone caught on to, telling you this, but yes, that's an unfortunate situation. If you're in an escrow right now and you didn't provide this form to the buyer and you're in a high or very high and you're going to close after July 1st, because you do have to give them this form now. And just the form itself does give them a right of rescission. I don't think most buyers want to rescind right now, and you can probably find another one if they do, but anyway, yes. Gene, yes, there are exceptions for protected trees, absolutely. Oops, but yes, that was a private note, but you're right. That is a good point to remember. There are special rules with like Joshua trees and special rules for certain types of trees. Yes, that the defensible space doesn't supersede that. Okay. All right. So this is kind of complicated. It's more complicated than any of the other disclosure forms, but I think you can deal with it. The form itself sort of breaks it down. Check out the Q&A that's going to be released later on today. There's an existing Q&A, but it doesn't, I modified it to make it more of a step-by-step process, sort of the way I just described it. Call the hotline. It's a complicated form. It's a complicated, the fire hardening part's not complicated. It's just the 4 options for defensible space are complicated. And the fact that the local company might not do it. And so you got to, you know, in other words, you have a new checklist. Number 1, am I in a high or very high? Number 2, is there a local ordinance requiring me to do something special? If not, number 3, does the seller have documentation or do they not have documentation? And number 4, on the buyers, so that's the listing agent checklist. Am I in a high or very high? Is there a local ordinance requiring me to do something special? Probably not. Number 3, does my seller have documentation from CAL FIRE or a local company that they're in compliance? The buyer's agent's new thing they got to do is, assuming it's the situation where the buyer has agreed within a year to do this, maybe assist the buyer, or at least tell them, or give them our Q&A, which it will have the CAL FIRE number on. It says, you want to know how you comply with this thing in the next year? Call CAL FIRE or the local company. Or you know what, I'll do it for you since I'm such a good agent. And of course, I want you to use me in the future on all your transactions. That's up to you. Legally, you're not responsible to make the phone call. And once escrow closes, you have no fiduciary duty to this person at all. But you're going to do it. You're going to do it what you think is you want to do with that. Okay, so listing agent, you got 3 new things you didn't have to do before. Am I in a high or very high? Is there a local ordinance? Does my seller already have documentation? Buyer's agent, you have 1 new job. Explain this to my buyer and maybe tell them how to comply, which is call CAL FIRE first, then call the local company. Okay, there we are. Let me go to, since we're still here, the other new form that's being released is, and it may have already happened, is called TOL, Transfer of Listing. Maybe you're a broker, you got an agent, and they want to leave, God forbid. And Jody is awesome. She really is. And your agent wants to leave and they want to take a listing with them. Or better yet, you have an agent coming to your office who has a listing who wants to bring it to you. Now, obviously, the listing belongs to the broker. The broker does not have to allow an agent to take a listing. But let's say you and the other broker are okay with it. You're willing to let it go and they want it. They might not even want it, but assuming they want it, you want, or vice versa, they're willing to give it to you and you want it. We have a nice form now where you can document easily the transfer. It covers release of liability to the other broker. It covers agency. It covers transferring files, and it covers compensation. Maybe you're saying, yeah, I'll let you take this listing, but I want some compensation for it. So nice form to transfer listings. That's the only other new form. As far as forms that you've already got that are changing, couple things. I'll save the best for last, or the most complicated for last. You know, the statewide buyer and seller advisory, the SBSA, the form that keeps growing. Every time a realtor gets sued, we add a new paragraph. Well, there are going to be 3 new paragraphs. One's going to be, remember, this is the not mandatory but recommended 15-page disclosure form you might want to give to your clients. There's a new paragraph on what I've just been talking about the fire hardening defensible space. There's going to be an interesting new paragraph. If any of you have properties on the coast, there's going to be a new paragraph on sea level rise, basically telling the buyers, you know, when you buy a house on the coast, sea level rise is coming. There may be restrictions in the future on your ability to build or improve or whatever. And then there's an interesting new paragraph regarding wildlife. I don't know about where you guys are, but more and more people have bears walk into the backyard or coyotes walk into their backyard. You know what they do then? They sue the realtor. You never told me bears could come into this property. So now we have it on the form that says, you know, you're in California, you buy a house, wildlife might come onto your property. Don't blame anybody for that. Okay. Yes, by the way, getting back to the transfer of listing form, it's between the agents, but yes, the seller has to agree to this, obviously. Sellers, that's another thing that could stop the transfer. The sellers could say, no, I want it to stay at this company. I listed with this company, not the agent. So yes, the seller has to agree also, yes. So that's a change. The I don't know if guys, you ever used the referral fee agreement. It used to say if you give someone a referral, they got to pay you if the property sells in X period of time. It used to say it had to close within X period of time. Now it says as long as you get into escrow within X period of time. That's not a big deal. If any of you have photographers you hire when you have a listing, you don't have to. We've always recommended you use the photographer contract called the PIA, the Property Images Agreement. It's now going to have a paragraph regarding drones where the photographer promises if they use drones, they will follow all laws and rules. And if anything goes wrong, they 100% are responsible. And then the most important thing to talk about is changes to your listing agreement, the form you probably use more often than any other form other than the purchase agreement. 3 changes worth mentioning. One is, I believe it's a very common practice now, especially where you are, that sellers order things not at the time of the sale, but at the time of the listing. So now the listing contract is caught up. So there'll be check boxes where the seller can indicate on the listing that I'm authorizing you to order a termite report, CCNRs, prelim, whatever, NHD. Remember the practice used to be years ago and still is some places, you don't order this stuff till you actually get a sale. but it's become fairly common for, as you know, for sellers to provide this stuff to buyers before they even get into contract sometimes. Okay. Also on the listing contract, you know, the whole concept of days on market. People come into listings sometimes thinking they know what that means, but they don't, because different MLSs sort of define that concept differently. So there's just going to be something on the listing form saying to the seller, you might want to have a conversation with your broker about what days on market means. Okay. Now, at some point, we're hoping there's going to be some universal definition of what days on market means. When that happens, the form will be tweaked again. Similarly, we're hoping there's going to be a universal definition of what coming soon means and what coming soon, what you can do. But that hasn't happened yet, and there's nothing on the listing form dealing. I'm just sort of just getting to that. Okay. The third, I think, and most significant, maybe controversial change to the listing contract is dealing with buyer letters, buyer love letters, whatever you want to call them. Background on this, of course, you probably are aware of two things have happened fairly recently. Number one is California has dramatically expanded the number of categories of protected classes under the fair housing laws. There's like 24 of them now. And there's also been an increase of lawsuits against sellers and landlords regarding fair housing. Put those two things together. One of the issues is, okay, it's become fairly standard, I think, that buyers, especially in a market where it's so competitive, and they want to stand out from other buyers, they don't just submit an offer, they submit a letter, a personal letter to the seller along with the offer. There's nothing illegal about that, but it can trigger fair housing issues in the sense that it's some sellers still have the mindset that, you know what, it's my house, I can sell it to whoever I want. It's not really true. In other words, you get two different offers. One is objectively better than the other, but you take the lower offer because the lower offer is from someone from your own ethnic group, and the offer that you didn't take, even though it was objectively more money, shorter escrow, better down payment, better credit score, but was objectively better, but you didn't take it. And you don't have a real good objective reason why you didn't take it, other than you happen to like people in your own, you know what I'm saying? Or that would be a problem. Sellers really aren't allowed to just sell to whoever they want. They can't. When determining to pick offer A over offer B, they cannot be making that decision based on the personal characteristics of the buyer. Not everything, but not their race, religion, color, skin, country, birth, age, gender, disability, gender identity, sexual orientation, source of income, immigration status, citizenship status, medical condition. There's like 22 of them. So the problem with the buyer letter is the buyer inevitably in the letter can reveal personal information. Sometimes they do it deliberately. My husband and I and our 3 wonderful children, including my disabled daughter, would just love this house. This house is perfect for our family, perfect for my daughter. And my husband it's a great place for him to open his dental practice. So we just moved here from, Vancouver, and this is the perfect house. They've just disclosed to the seller their marital status, whether or not they have kids, a disability, the source of income and where they came from. If I'm a seller, I really don't want to know that information because I don't want that to influence my decision. We all have biases we're not even aware of. From a risk management perspective, it's safer if I just don't know. So first of all, Gene, good question. Yes, you can favor a owner occupier over an investor. An investor is not a protected class. So that's legal. That is okay. You're not allowed to favor a family over a single person based on the family status, but you can certainly favor an owner occupier over an investor absolutely better. Investors are not a protected class. So that's a very good question. But anyway, so getting back to these letters, it's not that they're illegal, but you can see the possible problem. So there's a new paragraph on the listing form, which says, seller, you have two choices. By the way, there's also, of course, the fair housing advisory that you are, that is already attached, bundled with the listing and the purchase contract, which has a paragraph 8 that already talks about this issue that I raised. So ideally, your seller, when you're filling out the listing with them, they've looked at that, or maybe you've drawn it to their attention, whatever. So there's going to be a box on the listing contract where the seller has a choice. The seller choice number 1 is, you know what? I am instructing you, listing agent, that if you receive any letters, don't show them to me. I just don't want to see them. The other choice is seller can say, you know what? I understand what you're saying, but I still want the letters. Give me the letters if they come in. And then, but then it says, but I understand if I base my decision to sell based on the personal information that I learn from these letters, I am acting against your advice. So it's not saying you can't do it. It's just protecting the realtor from when the future problem happens, when the seller gets sued for bias on the argument that they sold to this buyer rather than this buyer for bad reasons. And they can't say, well, my realtor never told me I couldn't do that. Well, yeah, not only did they give you a fair housing advisory, but you actually checked a box on the listing form acknowledging that if you did this, you were acting against their advice. So that's pretty significant. That's really the only significant change, I think, to the listing. No changes to the purchase contract, of course, because everything's going to change in 6 months. Right. So that's pretty much it. Those are pretty much, that's a forms update. That's a COVID update. That's an eviction update. That's the new disclosure law update. The only other thing I think worth mentioning today is it's a big issue we don't even talk about anymore. Prop 19 is in effect, which is a good thing, I think, that if you're over 55 or disabled or a victim of a wildfire, you can sell your house, buy a new house anywhere in California and take your property tax with you. Even if you bought the old one a long time ago for a lot less than it's worth now, and you're paying property tax based on that low number. It used to be you could sell that and buy another house within the same county or a couple of other surrounding counties, but the new house had to cost less than the old house, and you could only do it once. Prop 19 significance is, even if you've already done it once, you can do it 3 more times. You can move to any county in the state, and significantly, you can do this even if the new house costs more than the old house. I'll give you an example. You bought a house a long time ago for $200,000. It's now worth 1.2 million. I want to sell it and buy another house that's worth 1.3 million. Before Prop 19, you couldn't transfer your property tax because the new house was more expensive than the old house. Now you can. So you sell your house that you originally bought for 200. So your property tax is based on that. It's now worth 1.2 million. I sell it for 1.2 and buy a new one for 1.3. What's my property tax basis going to be on the $1.3 million house I just bought? It's still going to be 200,000 plus 100, plus the difference between the purchase price of the replacement and the sale price of the old one. So it would be, it would be 300,000 rather than 1.3 million, which is a big difference. So this should the idea is this would persuade a seller whose hesitancy to sell is based on the fact that their property tax is going to go up astronomically to no longer have that hesitation. Now, someone's asking me a good question. Of course, there is a negative to Prop 19, and the negative is the rules have changed as far as transferring property to your children or your grandchildren. Prior to Prop 19, if you transferred your primary residence and up to an additional $1 million worth of real estate to your heir, the property was not reassessed. The change now is transferring property to your heir and avoiding reassessment only works if you're transferring a primary residence. So forget the other $1 million worth. And even a transfer of a primary residence works only if the recipient also uses it as a primary residence. So one point I always make on that is before Prop 19 came along, there was already a bill in the legislature to take away this exemption. So Prop 19, if you look at it that way, actually preserves something. Because the bill in the legislature, which I think would have passed, wasn't even going to still have an exception for transfer of primary residence to the kid who's going to use it as a primary residence. But anyway, yes, some people are complaining about that. Do I think, I'm being asked, that there's enough sort of blowback where the state may reverse course and go back to allowing transfers to heirs to not trigger reassessment, even if they don't live in the property, and maybe restoring that $1 million, additional $1 million. If you'd asked me that a few months ago, I would have said, there's no way it's going back. But now that the state has a surplus, there's talk. If I was a betting man, I'd say still, I don't think it's coming back. Okay. So there we go. You're right, Stephen. Prop 19 was passed by the voters. So it was a close vote, by the way, but it was passed. So yeah, I don't think it's going to come back. That's a good question. Oh, Stephen, you want to clarify what you meant by that? If I didn't.
What I was saying is that the piece that was lost in Prop 19 was an addition that was added to the Prop 13 initiatives that were added over the years to add more protection.
Right.
And so we lost that. So it wasn't really a net gain. It was like a wash because, you know, I have clients that have properties that they want to leave to their kids. And now these kids, you know, if you think about it, most of us that by the time we inherit a house have a primary residence of our own already. So you're not going to move into it. And it was a way to transfer wealth and increase, you know, the estates of families over time. But now it's going to be difficult because you're going to have to get a step up in basis on these houses.
No. Remember, that's two different things. Forget this is not talking about basis, this is talking about property tax.
Right, but for property tax purposes. So if you bought it, if the parents bought it at 250, now the kids are going to be paying property taxes at the current market value, right? So that's what I meant by step up.
It's definitely a negative, but I mean, Prop 19 was passed, and I was just being asked sort of privately, do I think that there's going to be a successful movement to reverse that? I'm just guessing. So yeah, I mean, that's I was just sort of speculating. I don't know. Yeah, I don't know. Nick, yeah, we're talking about transfers either upon death or while you're alive. In other words, this whole idea of triggering reassessment applies either way. Yeah. And of course, Joseph, you're right. Capital gains tax is a completely separate issue. The whole stepped up basis issue, that's completely distinct issues. That's completely different. Okay. So anyway, I think that's all I have for you. We're going to be waiting to see, obviously, what happens with the eviction moratorium. We're also, by the way, there's another thing I didn't mention. Another thing we're waiting to get rolled out is not only rental assistance, but mortgage assistance. Whereas someone who's had trouble paying their mortgage for COVID reasons, so they've been in forbearance and haven't had to make those payments, and now they're going to come out of forbearance, it looks like there's going to be a source of money for those people to apply for, to help them make those payments that they couldn't make, or maybe still can't make. In other words, federal money coming for that too, in addition to the rental assistance for landlords. Okay, so we're waiting to hear. That was supposed to be rolled out July 1st by the California Housing Finance Agency using federal money. Hasn't happened yet. We'll see. So we're waiting for that, waiting for the eviction moratorium. See if that's going to be extended. Probably will. I don't think about it much is going to happen immediately with any of these mask issue versus vaccination issue. There's probably going to be some definitive lawsuit at some point clarifying what you can, but right now the rule is very clear. You can, quote unquote, discriminate against unvaccinated people, and you can, quote unquote, discriminate against people who don't wear masks. Is that going to change one day? Who knows? But I'm telling you what the law is right now. So the other big thing then, for my world, of course, is going to be the RPA changes. So I'll see it, hopefully some of you, all of you, on whatever the date that was, August 26th, but we're going to be doing multiple classes. Unfortunately or fortunately, depending how you look at it, they're all going to be virtual for this year. So, but I encourage you to attend at least one of those classes. And we're going to do it a weekly webinar. We're going to have information out there for people who want to learn about the new purchase contract. So when it comes out at the end of December, you'll be ready. Doug, I am done.
Thank you so much, Gov. Thanks for being here. Great information as always. Really appreciate you taking time out of your busy schedule to be here exclusively with our association. So thank you.
My pleasure. So I'll leave while you guys finish up, but you know where to reach me.
All right. Thanks. Have
Bye-bye.
a great day.
Thanks, Gav.
Bye, guys.
Now I'd like to turn it over to Neil Collins, our CEO of SCORE, and he can give us some updates on what's going on with SCORE, with the office, our upcoming barbecue and events. So Neil?
Yeah, thanks, Doug. And thank you for everyone who joined us today. Hopefully you had some great value out of this. I also want to thank all of you who have kind of bared with us as we made it through this whole shelter in place. We've tried to be resilient, resourceful here at the association by offering appointments, member visits by appointment and curbside pickup, and a whole host of other benefits to you to ease you through. We've been doing that for the last several months. I think we were one of the first associations to really get out there and provide our services, actively in a real safe manner. So now we're in this whole new phase as California is opening up. So I just wanted to give you some insight. This week, we actually opened up the doors. No longer are you required to make an appointment. You can do walk-ins. But we've also maintained the ability for you to make an appointment. So if you want a specific time, you can still do that 24/7. You can make those reservations and you'll have a dedicated member service person waiting for you. We've also are going to continue to do curbside pickup because it's been very popular. People like that concierge type service. So that's going to continue to be available for you as well. But if you want to walk in the store, you're absolutely able to do that as well. Next week, we're going to make a formal announcement and let the membership know that we have unlocked the doors. So you guys are kind of getting a first glimpse of that. We wanted to do a bit of a soft opening this week just to get some of the kinks out. There's a few things as we started walking around the building that we needed to shore up and have ready for, hopefully the big crowds moving forward. And then starting July 6th, that's really when we're going to start doing all of our in-person events. Education will become available at that point. We'll still continue to do full webinar style, but we'll also introduce hybrid classes. And hybrid for us is going to be meaning a live stream class. So we may have 30 people in the classroom and maybe another 50 online. We've made the investments while we were in COVID, and we've just did some recent testing on it, and we're pretty excited to deliver that service to you. So again, trying to create a level of flexibility. We know not everyone's at the same spot with comfort level of in-person events. And we also want to extend our reach. Traffic is a big concern. We want to make sure that we remove barriers for you to get your professional development. So now moving forward to those big in-person events, our first one is on July 29th, and it's from 3 to 6. It's going to be our membership appreciation barbecue. This is a great event. We have hundreds of signups already for it. Please make sure you RSVP. It's a free event. And it's kind of our big, coming out party for the association. So I definitely encourage you to attend that. A lot of questions about our golf tournament. It is coming back. So our golf tournament is one of the largest fundings of our foundation. And that's going to be on August 24th at Cinnabar. We just opened registrations for that this week. Again, you probably want to jump on that quickly. That's going to be a great time. Lots of members connecting and networking, and it's for a great cause. Again, our foundation does remarkable work. And then lastly, for you at the brokerage level, I think it's important to note that this year is the third leg of the Code of Ethics cycle. So roughly about a third of our members and a significant amount of your individual offices need to get their Code of Ethics renewed this year. If you have a larger office and you're not sure what that looks like and you want to help us communicate to your members, please reach out to me personally. My email is Neil, Neil, @sccaor.com. And I'll have my team look up and send you a personal list of who needs to take the Code of Ethics. But there is quite a few members that need to take it before the end of the year. If you renew your license, that does constitute fulfilling your Code of Ethics requirement. And throughout the year, we'll have classes. We've had some free classes. We'll have some paid for classes as we start getting a little closer to the deadline. But we're hoping that you can be a partner with us in this process as the broker. Very critical for us to get all the members through this year. So with that, Doug, that kind of concludes my updates.
I think I'm frozen here. Can you hear me? I think I'm frozen.
We can hear you.
Okay. I think my internet's a little unstable. So I think that wraps us up. So if anyone has any further questions or comments, speak now. Otherwise, we'll go ahead and wrap this up. I appreciate everyone taking time and hope this was valuable for everybody. And I believe, Neil, we're going to try and do the next one live, correct?
Yeah, our goal is to do the next one live sometime in the fall, perhaps over at the Doubletree in a little bit grander fashion. Again, just trying to do a nice big reopening and getting back to face and seeing everyone.
And another question that people have had are the broker tours. And just an FYI, we're actually meeting with the tour leaders this afternoon at 1 o'clock to discuss our broker meetings and broker tours, virtual, in person, hybrid, how we're going to move forward with this. So we should have an update on this after our meeting today. So thanks everyone for coming. Have a great day.
Thanks, everyone.
Thanks, everyone.